Good morning, everyone. As Mayor Pro Tem, I call this meeting to order. Ms. Rebecca, if you can take roll, please.
Mayor Pro Tem Kaylin Paxson.
Present.
Council members Sylvia Campos. Eric Cantu. Gil Hernandez. Mark Scott. Carolyn Vaughn. Assistant City Manager Ernesto de la Garza.
Here.
Assistant City Attorney Lisa Aguilar.
Here.
Mayor Pro Tem and Council, a quorum of the Council and the required charter officers are present to conduct the meeting.
Thank you. At this time, I would like to go to our next item, which is public comment. Public comment will be limited to 1 minute per speaker this morning. And first, we have Samuel Andre Fryer.
Good morning, Samuel Andre Fryer. I just wanted to say I'm neither here to either support the mayor nor am I here to support those who have filed the petition. I'm actually here for one thing, and that's to encourage the tribunal to be forthright, to be truthful and unbiased, and carry those procedures in a way that without any ulterior motives. And that's so important because the good thing is we're doing this so that we can possibly get things on record. That's a good thing. So regardless of the outcome, that is a very good thing. But I wanted to say one thing. In the Bible, in Proverbs 18:17, it says, the first one to plead his cause seems right until his neighbor comes and examines him. So keep that in mind, and I pray that we will do the right thing when it comes to this. Thank you.
Thank you. Melinda de los Santos.
Good morning. I was Melinda de los Santos, District 2. I was determined to keep an open mind about that until I heard the evidence on both sides. However, I didn't think I was going to hear much evidence yesterday. No disrespect, Mr. Flood, but you pulled a Dr. Fauci on me. However, after hearing the evidence, I was wondering, is there such a thing as a RICO ruling for malfeasance, misconduct, incompetence, and willful neglect? Because throughout this whole process, from the beginning of this application all the way to the signed contract, this appears to be red flags everywhere. Just to name a few, requesting for funds for new FEMA requirements, disappearance of dates from screenshots, significant disparities of money granted between agencies, FEMA requirements versus street level activation, contracts signed before the second reading of City Council, or if not, the 4 turned into a 1, and then the verbiage of the second reading differing from the first. All I'm asking is for truth and transparency. Thank you.
Thank you. Kathy Fulton.
Hi, my name is Kathy Fulton. I'm from Port Aransas, Texas. And I just want to say one thing. Port Aransas and all these surrounding communities are affected by what happens in the city of Corpus Christi. And this matters to us too, okay? It really does. Because your actions impact your surrounding communities. And I just want to say that the poll that was online with Chris News says 70, I think it's 72 or 74% of the people aren't supporting this, don't want this. Only 14% are supporting or say that this should finish happening. I want you to think about that. Those are your voters. 74% of your voters are saying, don't do this. And I think you need to be paying attention. Thank you.
Thank you. Sean Merritt.
Welcome back again, everyone. Well, I'm a little sad. I brought a gift for the hitman journalist, some soap. He needs it. We'll leave that there for him. Just as soap cleans the body, tribunal, it is your job to clean the body politic. This is not Corpus Christi. This is Corpus Christi. And if you take the head of the snake, the body's going to follow. So follow the charter. Don't let Mr. Flood here use his 50 days to call 50 more witnesses and keep us here to the election, because she'll use 1,500 more mail-in ballots and steal it just like she did with Michael Hunter. Now, that's all I got to say. I wanted to finish from yesterday. Please make sure your minion gets that. He smells very bad. Have a good day.
Thank you. Ms. Rebecca, do we have any other commenters?
No, ma'am.
Okay, then that would conclude our public comment at this time. To commence the hearing, we will have announcements from the parties. First, from the legal counsel for the petitioners, and then the legal counsel for the mayor. Mr. Allison, are you ready to proceed?
Ready.
Mr. Flood?
Yes,
are you-
ready.
Thank you. Mr. Flood, you can call your next witness.
A respondent calls Council Member Sylvia Campos.
And we have an objection to that when it's timely. Yeah. At this time, we would object to calling any council person that is actively serving as a judge. Judges, I mean, quite frankly, if you were in a real courtroom over in Nueces County Court or anywhere in the state of Texas, if you tried to call a judge from the bench, which is essentially what they're trying to do, then that would just be immediately denied. There's actually Texas case law out there that says that if a judge gets on a witness stand and testifies just by doing so, by acting what may be perceived as their own interest, they automatically disqualify themselves. So just the act of getting on the stand and testifying and saying anything that might be perceived as being in your interest as opposed to the interest of the person asking the questions can be construed under Texas law as a reason for automatic disqualification. That's the law in the state of Texas, and that's the law in the state of Texas because we don't let judges step off the bench and testify. Specifically, that's also under rules, I think 605 in the federal rules. It is expressly disallowed, and of course, this tribunal has not adopted that rule, but it still offers good guidance to us in that it very clearly articulates that a judge cannot be called as a witness, period. Furthermore, it should not be allowed because even if you are witnesses, and by that I just mean if you have facts back to the date and time when some of these incidents made the subject of the impeachment occurred, even if you have some of those facts, the best evidence of those facts is actually looking at the video of what you did. It's all recorded. Looking at the video of what you said. Looking at the video of your reasons for whatever you reasoned or articulated, a lot of which has already been played. So the best evidence of what you did and why you did it at the time is recorded. Finally, the reason to do it is that there is not any showing whatsoever that any of you have unique knowledge, including Ms. Campos, who's the one he just called, have any unique knowledge of any of the facts of the case that are not either already in evidence or can be spoken to by a different witness who is not sitting as a judge. In other words, why would you put a sitting judge on the stand when you can get the testimony from other witnesses? And they've not met their burden to show that there are no other witnesses that can be called in order to address the issues. For example, if they want to talk to you about your discussions with somebody else, they can call that somebody else, unless, of course, it's a sitting judge. But that's another reason is because there's a lot of judicial authority out there that says when you can go get the testimony from another witness, you should go that route. Here you can do that, whether it's calling Peter Zanoni, whether it's looking at the video, whether it's looking at what you said at other meetings, all of that's been put in the record. It's already there. That really leads me to my last point, which is because there's no need to call you as a witness, any of you, and because there is available information from other sources, what it really boils down to, and we know this, they've been stressing it, Mayor's Council has been stressing it from the beginning, what they're really trying to do is force a square peg in a wooden hole. They're trying to pound it in there because they want to take the position that somehow you're witnesses so you can't be fair. That's an issue that's gone before the federal judge, and the federal judge already denied that request for a temporary restraining order based on that ground. Then they tried again with the federal judge asking for what we call a preliminary injunction, and the federal court denied that request for a preliminary injunction. And then they tried to get what they call a permanent injunction, and the federal judge dismissed their lawsuit. And then they appealed it to the federal court, the United States 5th District Court of Appeals. They appealed it to the U.S. 5th District Court of Appeals and asked on the same reason, the same basis that we're talking about now. They said, well, you all, this group cannot be the judges. And therefore, they argued, Mayor argued, therefore stop these proceedings as unconstitutional. But instead, the Fifth Circuit Court of Appeals said no, thereby clearly giving their blessing that these proceedings are constitutional and that we should follow accordingly. So this argument that they're making is one that has been rejected over and over and over again. And you might recall last time when they called Councilman Roy, they said that, and I don't know if this is true or not under the case law, they said they had an obligation to, their words, try. They said they had an obligation to make an attempt, and that they're doing that, calling you as witnesses to try or attempt having you be witnesses as a means to what they think is preserving error for some subsequent lawsuit they want to file in order to, again, just like they did in federal court, they're going to again try to find these proceedings unconstitutional. So it's really just in that sense, they're really just more of a ruse to, and this goes back to all of the arguments, the reason under the federal rules and the reason under the other case law that we don't allow judges to be called as witnesses is because it really is a way to, if you allowed that, every criminal defendant would stand up during a trial and say, I want to call you, judge, as a witness. And it would just destroy the decorum of the court if you let the judge step off the witness stand and step off the bench and step onto the witness stand. It would destroy the integrity of the process if you let the judges move from the bench to the witness stand. Because again, the minute the judge says something that upholds the integrity of the process or talks about facts known in the background or the history of the process, all of a sudden it's gonna, you know how we lawyers are. They're gonna start asking pointed questions, they're gonna infer things, they're gonna say things, they're gonna attack the judge's credibility, and then the judge says something maybe honest in defense of their credibility and their stances of being committed to unbiased rulings. And it is just a way to destroy the integrity of the process, and that's what they're trying to do, okay? So there are multiple reasons really supported by federal rules, by Texas case law, by also the history of the case. The judge has already made rulings that you may be the judges, okay, and you may proceed. And once that ruling is made, we have to protect the integrity of the process and not allow it to be the ruse they want it to be, which is a witch hunt on you guys, rather than focused on the impeachment and the issues relating to the impeachment of the mayor. For all of those reasons, we would respectfully request that the objection I'm now making be sustained, and that if needed, that there be a motion to sustain the objection, and that it be granted. Thank you.
Thank you. Mr. Flood, would you like to?
A judge who is a fact witness or has a bias is required under Texas and federal law to recuse and disqualify themselves sua sponte, so without motion. Councilman Barrera and Councilman Roy recused themselves for that very reason, that being they are fact witnesses. A material fact witness, I'm calling Councilwoman Campos because she is a material fact witness. I'm also calling her to elicit bias testimony. The questions that I would ask her about the facts that she brought with her into this proceeding are those that are unique to her, and so I would have to ask her about any sort of receipt of confidential EDC information that she might have received prior to this proceeding, and the reasoning and knowledge that she had outside of the February 20 meeting, the reasoning and knowledge that she had outside of the April 23 meeting, her reasoning and knowledge outside of the meetings on the first reading and the second reading, her reasons, votes for any reasons outside of what was stated within the meetings. I would ask her about her communication with petitioners and their counsel about the allegations in the articles. There is testimony already in the record that she privately met with Philip Ramirez in a phone call. He testified about that. And that was before the April 23 vote. I could go on. I'm willing to make a proffer, or I will make a proffer if I'm not able to ask the witness, but there's much more that I will make as part of my proffer. The fact is that she is a fact witness, just like Mr. Barrera and Mr. Roy, and both of whom were deposed by Mr. David's counsel in the parallel David litigation that contains the same allegations. They were both listed as witnesses. The fact that that Ms. Campos was chosen not to be deposed does not mean she wasn't a fact witness in that case and in this case, for the same reasons Mr. Barrera and Mr. Roy were. I am entitled to ask her state of mind when she voted to retain outside counsel Daniel Ray, when she voted to investigate the allegations, any bias or prejudgment she had formed at those stages, the authorization of public funds for the investigation, which we have heard were that from Councilmember Cantu and Councilmember Vaughn in the January meeting were for investigation of the mayor and other council members, according to statements by council members in that meeting. I would offer evidence regarding her private conversations with the mayor regarding this proceeding, which are obviously relevant facts. There was a March 24 meeting in this chamber about advancing the articles of impeachment, where Ms. Campos made statements indicating that she sees this proceeding as the only way to address conduct by Mr. Ramirez. And so I would intend to ask her questions about those beliefs that she brought with her to this trial that started on July 22nd. And then I would also ask her about beliefs that she stated on March 24th that prejudge the mayor, where she states that she believes the mayor, quote, should be sanctioned, end quote, which is a statement made prior to the beginning of this proceeding. And so I would disagree with the argument that she is not a material fact witness in this case, and I would disagree that I'm not entitled to ask her questions about her bias. The fact that the two federal courts elected to allow this proceeding to go forward does not mean that the record is not allowed to be made in this proceeding regarding the very gravamen of the relief that was requested in the Fifth Circuit. The case at the Fifth Circuit remains. It's still there, and I'm entitled to make my record in that regard. And that is what I intend to do, and I ask Councilwoman Campos to take the stand.
Thank you, Mr. Flood. At this time, I'm going to call for a motion to either disallow the testimony or grant the objection.
Oh, well,
That would be the same thing, just so we're careful on wording. It's okay.
Thank you. Yes. Motion to sustain the objection and a second. All in favor say aye. Aye. Any opposed, say nay.
Nay.
It's sustained.
Um,
Ms. Campos, for record, did you place a vote on this item? Abstained. Thank you.
on the, just now, the last vote just now. That's, I'm sorry, I'm just asking a clarification. Was that a reference to a prior vote or the vote just now?
Just
Just
no.
now.
Okay, thank you, I
Thank you.
appreciate that. I was just making sure.
Yeah, that is, I believe, the correct thing to do.
Thank you.
Thank you.
Yeah, make my proffer now? Okay. Were Ms. Campos on the stand, I would ask her questions about her receipt of any sort of information outside of the record in this case prior to this proceeding, including any information regarding EDC, I'm sorry, regarding Type B E-session discussions, any sort of EDC discussions, her reason, and communication with, I would also ask her questions about her communication with any of the petitioners, including Mr. David, any communication with counsel for Mr. David, communications and relationships regarding whether or not she has ever been represented by Mr. David's counsel. I would ask her questions about the allegations in the articles and whether or not she's had any communications with the petitioners or their counsel about any of the allegations or the facts underlying the allegations in the articles of impeachment. I would ask her about her reasoning and knowledge, reasoning behind and knowledge outside of the record, a public record regarding her votes on the February 20 meeting. I would ask her the reasoning and knowledge outside of the public record regarding her comments, both at the February 20 meeting and the April 23 meeting, and the reasoning and knowledge of information outside of the record regarding her decisions at both of those meetings. Her reasons for voting are facts in this proceeding, based upon both the facts and the implications and inferences raised by the articles of impeachment. As I stated earlier, Mr. Ramirez has already testified, it's already in the record, that he had a conversation, a phone call with Ms. Campos before the April 23 vote. And this is a private conversation. And after the controversy had arisen, and I would ask her questions about how long it was, whether or not she recorded it. Do you know if he did? I would ask her the communication that she received from him and her receipt of it and her evaluation of his credibility, whether or not he explained to her that the alteration of the slide was a mistake that has been suggested by him in other contexts, whether he denied that the alteration was done intentionally, whether she believed him, whether she asked him any questions, her evaluation of whether or not his explanations were believable. I would confirm that there's no recording, no transcript, and today that only she can provide us with her impressions that she brought with us to this proceeding based upon that private conversation with Mr. Ramirez. I would also ask her questions about becoming part of the investigation and her state of mind when she voted to retain outside counsel Daniel Ray. And much of these that I'm about to go over are also reflected in a later public statement. And so the state of mind, her state of mind in regards to these issues would be something I would ask her about. You voted to investigate the allegations to get home suites, participate in executive sessions, authorize expenditure, and those were based in part on her own understanding of the underlying facts, which were uniquely gathered by her in her private conversation with Mr. Ramirez, and potentially in other conversations that are not part of the record with Mr. David, Mr. David's counsel, petitioners, and other persons. I would ask her questions about why she made certain comments to Mayor Guajardo, what motivated her to make certain statements to Ms. to Mayor Guajardo, and her beliefs that she shared with Mayor Guajardo and why she formulated such beliefs. That she stated to the mayor that she wanted an apology from her prior to July 22nd, 2026, before this trial started. I would ask her questions about what was in her state of mind in that regard, whether or not she believes she received it, whether or not that is a bias that she brought with her to the proceeding. In March of this year, March 24th, there was a council meeting held 4 months before this trial started, where she stated publicly certain beliefs. She used the word beliefs. She stated that she believed that the steps taken by Mr. Ramirez to mislead the council should be considered illegal. She stated the belief that his steps were intentional. She spoke to Mr. Ramirez. Again, she spoke to him on her own individually, and that, without a doubt, would be part of her state of mind in formulating that opinion. She references in her public statement on March 24th that Mr. Ramirez had contributed to the mayor's campaign, which is a state of mind for her that is some sort of, apparently some evidence that helps her formulate the beliefs that she shared about the facts underlying the articles of impeachment. And again, she expressed the belief, quote, belief, end quote, that the only way to stop this kind of dealings in business as usual is to address it directly, and she believes that this proceeding is the only way to directly deal with it, and that for that reason, that is her belief as to why she's moving forward with the hearing. Those beliefs were brought into this trial on July 22nd. Again, the only wrongdoing addressed is in her statements is that of Mr. Ramirez. And those beliefs were brought to trial. Another belief that she had on March 24th and that she brought with her into this trial is that the mayor should be sanctioned. I have a text message that she sent while sitting on the dais on March 24th at, well, no, the text string begins while sitting on the dais, and then that evening at 6:38, she states, quote, "I do not believe in removal. I do believe in a sanction. It can't happen unless we move forward." And I'm going to mark that as Respondent's Exhibit 65. That is a belief she had on March 24th that she brought with her into this trial, and that is that...
Mr. Flood, could you provide that date?
Yes, I will. I was just going to finish that sentence before I got up. Is that the sanction that the mayor deserved, that she believed that she deserved on March 24th of this year, can only happen if the council moves forward with this removal hearing. I'll bring this forward. I don't have them all marked as 65, but
And I assume the offer is that the offer is not into evidence, but for purposes of the offer.
this is a proffer only.
Thank you.
I'm just going to give it to, I'm just going to give it to special counsel. My next witness would be Mr. Hernandez.
Yes.
Mr. Flood, can you give us 2 minutes with this new information?
Sure. It's...
Okay, thank you, Mr. Flood. If you'll proceed.
I'll call my next witness, council member, Mr. Hernandez, please.
And may I be heard on my objection?
Yes.
With the tribunal's permission, I gave a lot of objections last time. It's long to explain it all. May I adopt those by reference?
Yes.
Thank you. We make the same objections to calling Mr. Gil Hernandez, Councilman Gil Hernandez, as we made a moment ago when I was making objections to calling Councilwoman Sylvia Campos.
Thank you. Mr. Flood?
And Mr. Hernandez is called for the same purposes, and that is to establish that he is a material fact witness and also to establish his bias in regards as a fact finder and judge in these proceedings. He'll be asked questions about the bias and the facts that he understood that brought him to that he brought with him into this proceeding. A judge is required under Texas and federal law to recuse and disqualify themselves sua sponte, much as Mr. Paulette and Roy did recuse themselves because they are fact witnesses. I would establish that Mr. Mr. Hernandez, my apologies, likewise is a fact witness and brought with him certain biases. I would ask him, like I would ask Ms. Campos, about his receipt of confidential EDC information that he received prior to this proceeding, his reasoning and knowledge and state of mind outside of the record, which are obvious, are almost that are clear from the February 20 meeting, which I will get into in a minute. I'm happy to make my proffer, have the objections sustained, and then make my proffer, if that's okay.
Yes, thank you. At this time, I'll call for a motion to grant the objection. Motion? There's a motion and a second. All in favor say aye. Aye. Any opposed say nay.
Nay. I abstain.
Thank you, Mr. Hernandez. Mr. Flood?
Okay, thank you. As I would have with Ms. Campos, I would ask Mr. Hernandez questions about his receipt of confidential EDC information prior to this proceeding, the reasoning and knowledge outside of the record that he brought with him to the February 20 meeting, his reasoning and knowledge that he attained outside of this chamber and meetings prior to the April 23 meeting, his reasoning and knowledge that he received outside of the record for his decision on the second reading, and his reasons for those votes and the reasoning and knowledge that he brought with him outside of this outside of the record currently are facts that he brought with him into this proceeding. On the specific to the February 20 meeting, he pulled the item from the consent agenda. I would ask him reasons why he did that. And I would ask him questions about the preparation that he made prior to the meeting, all discussions, his personal knowledge that he received from conversations from anyone outside of the proceeding on that day that that are public. And I would ask him about his that he researched the item beyond simply reviewing the agenda packet that contained the altered slide. And at the, if you can go to the head discussions, I'm well aware. Oh, yes. I will play a portion of exhibit, what is it? What's our number?
It's the 220 meeting.
Our petitioner's exhibit of the video that's already been played. I'll ask, can you just play that real quick?
Yeah,
Thank you.
Exhibit 6.
Part of exhibit 6.
By Hilton at the corner of Chaparral Street. Who pulled this one? Councilman Hernandez. Your question or comment?
Yes, question. And I'm familiar with this. I've had a couple of discussions about it. We're well aware of the disparity between what the EDC had recommended and what the Type B had done. My concern is not so much funding.
Good. Thank you. I would ask him questions about how he became well aware of the discrepancy. I would ask him questions about the research that he had done simply beyond reviewing the agenda packet. He said he had a couple it sounded like about to say he had a couple calls about it. However, he then changed that word to discussions about it. I'd ask him about whether or not he had any phone calls with anybody outside of city staff about the item and his knowledge outside of the public record. I would ask him how his awareness of the disparity, whether it became knowledge that he had outside of the public record that was included within the agenda memo for the February 20 meeting. I would ask him questions about his knowledge regarding the mayor on the EDC board. I'd ask him any questions that I'd ask him questions about his contacts with Mr. Hunter or anyone else that sits on the EDC board prior to the February 20 meeting. I would ask him if he was aware of any of the discussions within the EDC meeting. And again, this is not evidence that's being admitted right now. This is just part of my proffer. In those conversations he had, I would ask him what he learned about anything that happened both in the EDC meetings and in the Type B meetings, whether those were the latter, the Type B meetings being either whether he learned anything that came from closed session or whether he learned anything that came from the public meetings. What he learned about what was described as a spirited discussion within the EDC meeting. What did he learn whether the timing, the FEMA timing narrative was addressed at the EDC meeting, and whether he learned anything that suggested whether the mayor learned anything prior to February 20th related to this, to the FEMA narrative or the slide itself, and whether he learned anything that suggested whether the mayor was informed that someone at the EDC meeting may have expressed skepticism about the FEMA narrative. I would ask him questions about that. Again, since he's not being allowed to testify, that is not going to be part of the record. Let's learn, and then I would ask him about his conversations with Mr. David or Mr. Gully or Mr. Hunter or the mayor or anyone else on the EDC board, and ask him all about the concerns that he had about the item before the first reading, because he stated that he had concerns. And one was why the Type B went with the requested number and doubled the EDC. I'd ask him why it didn't sit right with him, why it gave him a concern, even though he understood that the Type B board does not have to give a reason. And I would ask him that the lingering thoughts that he had and why he pulled the item to try and understand, and that he was doing more than the other members in regards to this. I would ask him about why he spoke to Alyssa about the public investment, why, and the statements he made about that. I would ask him his concerns or goal, whatever it was, to be in regards to being, in that he stated, quote, "We should be fair and have funding come from Type B for those other hotels as well," and quote, "If we set a standard, make sure we adhere to that standard for everybody." I would ask him about that because we know that Mr. David and RGB had received TERS in the past, and we know that they've requested Type B since, and I would ask him questions about whether he was looking out for those particular donors of his. I would ask him whether or not Mr. Hunter ever expressed skepticism to him prior to the February 20 meeting about either the FEMA narrative or perhaps even the altered slide. I would ask him about the apparent repeat of the narrative by members Suckley, Roy, the mayor, and also Mr. Culbertson, and whether he and his reaction to those repeats of the apparent narrative. I would ask him about that he knew prior to the February 20 meeting that the Type B rejected general FEMA compliance and was not presented, and was not actually, and that the actual reasoning of the Type B board was not presented to the council because it wasn't presented to the council on February 20th, and but the record indicates and I would ask Mr. Hernandez about it, that he already knew that. Because after Mr. Hunter brought up the incredibility of the FEMA narrative, Mr. Hernandez stated, can you put the next clip up, please?
And Hernandez.
Okay, so every project that would be downtown would be in a flood zone, right? So are we going to give the benefit to everybody that's downtown that's in a flood zone? That's almost incentivizing you to build in the flood zone. So I don't want to tie it to this flood zone thing. It's not, and it shouldn't be.
It's not, were the words relating to this incentive, where the agenda memo said that it was. And so Councilman Hernandez's statement makes him a unique fact witness, because it appears that before February 20th, he knew that the Type B board's reasoning was not related to general FEMA compliance. And that makes him a unique fact witness. The slide that was prominently displayed, the comments from the mayor, they didn't reflect what the Type B had actually based its decision on, but Mr. Hernandez apparently did. And that was based on the discussions that he had prior to the meeting. Apparently, it was personal knowledge he developed and brought with him to that meeting that he still has to this day, that will not be revealed through questioning. He voted in favor that day because he knew the FEMA narrative was not material to the Type B board's decision. I would ask that question directly. And he voted in favor because the council did not disagree with his notion that we need to be fair and have funding come from Type B for those other hotels as well. And if we set a standard, we got to make sure we adhere to that standard for everybody. Between February 20th and April 23rd, I would ask him questions about his interactions with Mr. David. I would ask him questions about whether he reviewed the Type B meeting materials, whether he met with Ms. Hurlbert, whether he met with Ms. Oliveri, which I believe is true. I'd ask him questions about whether he met with Miles Risley, whether he met with Peter Zanoni. And there is also in the record already from Mr. Ramirez's deposition, the question answer where he said, which was played earlier, that he was in a meeting with Gil, Everett, and Mr. Ramirez, where Mr. Ramirez explained to them that it was an inadvertent, accidental, not intentionally done, whatever word, well, that's Mr. Allison's question, whatever words you used today to describe it, something along those lines, yes, that would be accurate, yes. And you made it clear in your explanation to all of those. I would ask Mr. Hernandez questions about his assessment of Mr. Ramirez's credibility that he formulated at the time and brought with him into this proceeding. I would ask him about whether or not he took any notes, if he has any notes related to that meeting that he could share. And so one of the allegations in this proceeding is that Mayor Guajardo somehow improperly favored Mr. Ramirez. I would ask him about that and whether or not he had formed some opinions about that prior to this. He got to have a firsthand assessment of whether Mr. Ramirez was telling the truth about the slide. It wasn't on a phone call. It wasn't anything. I'd ask him about the questions he asked Mr. Ramirez, why he asked those questions, evaluate, in that he formulated impressions about his credibility prior to this proceeding. And I'd ask him whether or not at that time he had seen the actual PowerPoint at any point prior to this proceeding, when and in what context. I would ask him about the impressions that he left with the meeting with Mr. Ramirez. I would ask him if he, it says the articles of impeachment assert that the mayor was advocating for the person and not the project, and I would ask him if he, I would want to ask him if he has any understanding of what Mr. Ramirez had said to the mayor at any point along the way, if he has any knowledge about that. All fact gathering he engaged in that caused him to want to postpone the April 23 meeting. If review of the record indicates that he said he had 2 reasons to get the unresolved issue about how they arrived at the $2 million, but also for Mr. Zanoni to complete his investigation. I'd ask him questions about his state of mind at the time in regards to both of those issues. I'd ask him questions about why he had the Type B board president present on April 23rd, and he did not inquire of that person regarding the unresolved issues he had about how it is that the Type B board arrived at the $2 million as opposed to the $1,043,000, and his state of mind in that regard, and the reasonable inferences drawn therefrom. I would ask him about the executive session on April 16, and whether or not his recollection is that of the same of other witnesses, and the presentation that neither Peter Zanoni nor Mr. Risley ever, or whether or not his impressions after the meeting are that he'd never heard in the meeting that, it's kind of interesting to not violate the executive session rules in a proffer. So whether or not he also shared the other witnesses' formulation that they did not leave that meeting with the impression that any crime had occurred, but that there were only allegations, which is a central fact to the articles of impeachment. I would also ask him questions whether he understood what the recommendation was from staff, and when he entered the April 23 meeting, whether he understood that it was recommended to be considered or whether it was not recommended. And that is an important fact issue regarding one of the articles. Your understanding about the time about why it was being put on, I'd ask him questions about why, his understanding about why it was on the agenda and why it was not allowed to be on the agenda. I would ask him about the April 23, that going back to the February 20, and he stated on April 23rd, it's a very long agenda memo that talked about all the issues that came about, and unfortunately, via various reasons, the presentations and the information didn't always match up with what was actually happening, end quote. That was a quote of Mr. Hernandez at the meeting. And so I would ask him questions about the various reasons and whether EDC and staff simply pulled the EDC material presentation to the council, bypassing the actual reason that Type B gave, which he called editing of the slide. And he referenced that Mr. Ramirez and Bacta hadn't responded to the city manager's inquiries. And because of the, end quote, now because of some of the issues with the presentation which Councilwoman Campos had pointed out, there was some editing, so to speak, and we're waiting on a response. And he claimed there were muddy waters, but they were not muddy for Mr. Hernandez, because he knew before February 20th that the Type B board's reasoning was not based on general FEMA compliance, because recall his statement was, it isn't. He made the motion that it was for everyone's protection. And the motion that he made that the second for was withdrawn was for everyone's protection. I'd ask him questions about what he meant by that and what it is that he was trying to protect the public from. And let's see, and I would ask him about his belief at that time, because he had questioned, he stated, and I will quote, that's okay, I'm just going to read it, and I quote, I will clarify that in the sense that the request initially was for funding or for flooding mitigation, right, which was discounted, but it's the exact same dollar amount as to what was actually provided by Type B, which is the narrative that the petitioners in this case have actually put on. It's the same factual narrative. It matches the petitioners. So I would ask about coordination with petitioner's counsel, any communications between himself and commissioner or counsel, and really any lawyer that is associated with Petitioners Council. I'd ask him questions about that. Going back to it, I will clarify in the sense that this is Mr. Hernandez from the April 23, was for funding or for flooding mitigation right, which was discounted, but it's the exact same dollar amount as what was actually provided by Type B. So just make sure that there's no confusion. I want some documentation as to how they arrived at their number for the $2 million, just to make sure everybody's protected. So that's my motion, even though the Type B board president was right there. And when she said, I'd be, quote, I'd be happy to answer any questions, and Mr. Hernandez later on said, I don't need to say anything more, rather than asking her questions on the record on the very issue that he espoused was important to him. He made a motion for the Type B to state its reasons. I'm looking at this to protect us as an organization, as a city. Again, I'm quoting Mr. Hernandez. I'm looking at this to protect us as an organization, as a city, so we don't have any, lingering thoughts of malfeasance. I would ask him his preparation for that meeting, that he had sit down with Mr. Ramirez, studied the issue for 2 months, and he had the chair of the board who made the decision there, and he didn't ask her any questions about that. About how it is that the number was arrived at, the $2 million, the basis for it. In August of 2025, August 29th, 2025, I would ask Mr. Hernandez about an email that he received that contained the petition for removal that had been filed with the city secretary. I would ask him about the news breaking the following day that the petition alleged the mayor was guilty of, quote, malfeasance, end quote, the word he used at the April 23 meeting. I would ask him questions about how 5 months later, in January, when the Corpus Christi Police Department was on the agenda to publicly discuss its findings in the Project Elevate investigation, Chief Markle was there, Investigator Garcia was there, Breedlove was there, and there was a presentation for public consumption for the investigation details. And I would ask Mr. Hernandez about the fact that he had read the report and he knew that the police were there to answer questions, but something happened at that meeting. Mr. Hernandez made a motion to postpone the police department's presentation, and even though the police department had completed its investigation and the report had already been delivered, and he understood the investigation had been closed, and that he understood that the presentations concerned the police department's findings, but he also at the same time understood that the council had hired outside counsel to conduct a separate investigation, and he stated that he expected that to be delivered in February, and he moved to delay it, which was a successful motion, to delay the police presentation. And he explained that he didn't want to put the police department in a bad position, and that he didn't want the police department report to be utilized for public purposes, which were his words. I don't want the police departments in the law enforcement investigation to be used for, quote, political purposes. And when he was referring, I would ask him questions about the political purposes he was referring to, and those were asking questions about whether they referred to the controversy involving the articles of impeachment that are before this proceeding right now, in which he is sitting on the dais as a juror in. And he, at that time, knew that the removal petition had been filed against the mayor. He knew that the police department investigation had become part of the public discussion surrounding this proceeding, and he was concerned. I would ask him questions about the fact that whether he was concerned about how the police department's findings might affect those discussions regarding this proceeding. I would ask him questions about whether he wanted to wait because the attorney's report, quote, might be contradictory, end quote, to the police department's report. And those were his words. So before either presentation occurred, he anticipated that the lawyer's conclusions could differ from the police department's, and believed that the lawyer might reach findings that the police department had not, and that expectation was the reason he wanted to postpone the police department presentation, even though it was ready to be presented, because it would counter the narrative that had begun after the articles of impeachment, or I'm sorry, after the petition for removal had been filed months later. I would ask him questions about whether the police department he understood were ready to present. I would ask him to confirm that the police department did not ask for a postponement, instead that he did, and that and I would ask him questions about the fact that what he wanted to do was change the timing of when the public would hear the police department's conclusions to fit the impeachment narrative that was initiated in the petition for removal. I would ask him questions about that he knew the removal proceeding against the mayor was pending at that time, obviously. I would ask him that he understood prior to that meeting that there had been no finding of criminal conduct by anybody involved by the police department, and that he expected the lawyer's report to address alleged misconduct by elected officials, and that was the reason to delay to try and manipulate the narrative regarding the pretrial proceedings in this matter. I would ask him to confirm his state of mind that the investigations involved many of the same underlying events, and I would ask him questions regarding whether his intent was to have them released together rather than allowing the police department conclusions to stand on their own in order to match the narrative surrounding the articles of impeachment. And they were done all in an effort to try and shape the narrative leading up to this trial. I would ask him to confirm that his concern was not whether the police department had actually completed its work, but that his concern was how its conclusions would be received before the lawyer's report was released, and that is why he sought the delay. He stated, quote, "I don't want to put you in a bad spot or have you utilized for political purpose, so I want to make sure that we have all the information at the same time." And one of the justifications was that the police findings would be used for political purposes, and Mr. Hernandez has publicly confirmed that this removal proceeding is a political process and not a legal process. I would ask him to confirm that a policy is something that focuses on written rules and guidelines and goals, and it answers what actions will be taken to fix an issue. And politics focuses on power, campaigns, elections. It involves conflict, debate, and compromise between people. It answers who gets to rule and how they win support. And I would then return to the facts of the petition, the timing of the petition for removal, the postponement, the Corpus Christi Police Department and Daniel Ray presentations in February, and that less than a month later, I would ask him about his state of mind of signing the three-signature memo, initiating the three-signature memo dated March 11, 2026. And I would ask him questions about his public expressions of a willingness to run for mayor. I would ask him questions about his decision and state of mind to sign the three-signature memo and to put this removal proceeding on the agenda to start the process, and that it was a political decision to sign the three-signature memo. And I would ask him, do you have the clip? Ask him about a...
The city secretary has some authority to put stuff on the agenda, but she just didn't want,
I'm going to ask him questions about his state of mind on, do you know the date that was? It's okay. On April 29th, just 6 weeks after signing the three-signature memo, and that his state of mind in signing the signature memo was not founded on policy, and it was not founded on anything other than politics. And this, I would confront him with this statement, that public statement he made.
The city secretary has some authority to put stuff on the agenda, but she just didn't want, she wasn't going to. And no...
I would confirm with Mr. Hernandez that that is his voice that we hear in that clip. Go ahead.
Staff member would ever do it, because it really is a political process. Yeah.
Well, so given the
Political
situation,
process, not a legal process?
no, well, the charter is is an ordinance, right? Or it's voted on by the citizens, right? So we're following that process. But any kind of these things is to put stuff on the agenda is by the policies that we have in place.
I would ask him to confirm that the memo itself is the policy, but the decision that he made in his state of mind when signing it was, as he stated publicly, political. I would ask him questions about in November, the November 7, 2023 Proposition A, that voters in Corpus Christi considered Proposition A. Proposition A, I'll ask him questions about Proposition A would have supported the renewing of a 25-cent sales tax and dedicating the revenue to constructing and renovating regional parks, convention center complex. I would ask him to confirm that Mr. Ajit David, a petitioner, a person in this case who's identified himself as a petitioner, who is sitting right now next to Petitioner's Counsel, who is has been at these proceedings as far as I can tell every single day, and I would ask him to confirm that, as I think he would, that Mr. David and Mr. Raju Bhagat were opposed to Proposition A back in 2023. I would ask him to confirm that in 2024 he was the chair of the Audit Committee, and I would ask him to confirm that on August 28th, 2024, the Auditor's Office received an allegation regarding a $2 million incentive to the Homewood Suites by Hilton at the corner of North Chaparral Street and Lomax Street in downtown Corpus Christi, and that according to the allegation, a government document was altered to obtain tax dollars from the Type B Corporation. I would ask him to confirm as auditor, based on his personal knowledge and in his capacity as chair of the Audit Committee, that Mr. David is who made that allegation. And Mr. David I would ask him to confirm his personal knowledge that Mr. David is a partner in or affiliated with Bayfront Marina Investments LP, and that he was chair of the Audit Committee, as I stated, and that the following day, the day after August 28th, 2024, on August 29th, 2024, Bayfront Marina Investments donated $1,500 to Mr. Hernandez, and then a month later they donated 1 month later. And I would ask him questions regarding his statement that he made and that has been published, that regarding that payment, he denied that. I would ask him to confirm that he has denied that that the money related to the audit complaint, even though it was paid the day after Mr. David made the complaint, and that the other payment was made only a month later, and ask him to confirm that he affirmatively that it was his state of mind prior to this proceeding, where Mr. David is a petitioner and has been sitting here as a party in this proceeding. Ask him to affirmatively confirm that the money was paid to Mr. Hernandez, quote, for, end quote, his opposition to Proposition A, which had been voted down over 9 months earlier, and the incredibility of the timing of a payment of $1,500 on August 29th and its relation to something that happened on August 28th, and his statement that it was for opposition to Proposition A. Can you play that clip, please?
Was that timing just a coincidence?
It's just retaliation.
I'm talking about the contribution.
No, it was for something different.
Had
We
nothing
had-
to do with what was going on?
No, we didn't support Proposition A in 2023, which was funding for a hotel a convention center hotel.
Need some help?
No, I got it.
Yeah.
It was funding for a convention center hotel that we didn't support.
And I would ask him to confirm that the person or the entity that paid the money on August 29th and a month later on September 30th, I believe, something like that, approximately, is an entity, was number one, an entity, and number two, Bayfront Marina Investments LP, and number two, that a principal of that entity, Mr. David, signed the articles of impeachment in this case. Finally, I would ask Mr. Hernandez questions about very recent statements made after the initiation of this trial, specifically last Thursday, the 30th, at the Del Mar Small Business Center on Costores. I would ask him to confirm whether or not he made the public statement that when asked if he's going to run for mayor, whether or not he said, quote, "First, we have to get rid of Paulette," end quote. And that ends my proffer of Mr. Hernandez's testimony. And with that, and I'd want to make sure the affidavit of compliance, which was marked as Exhibit 64, I think that was 64. Yeah, that's what I mean. The affidavit of compliance is Exhibit 64. Yeah, I'm going to go ahead and offer Exhibit 64.
No objection.
All right.
The only housekeeping item I have with that is, go ahead.
I asked that 64 be admitted.
Yes,
and there's
admitted.
Okay, thank you very much.
Sorry about that.
No
And so
objection.
with that, respondent rests.
Thank you. A rebuttal?
Yes, at this time we call Brian Gully.
And I have an objection to the rebuttal because that needs to be heard before Mr. Gully is brought in. Okay, let me grab that.
Okay. While we allow him to prepare, we'll take a 5-minute recess. Thank you.
I turned off his sound, and the video
There
of
we
him
go.
seeing us.
Okay, all right, then
So I
I
think I did the
believe
right thing.
everything's in order now, so we will call this meeting resumed. Thank you. Yes, Mr. Flood?
Respondent having rested, it has been indicated that there is rebuttal evidence that is going to be at least offered. The rebuttal evidence that I've received notice of is not rebuttal evidence, and so respondent objects to this improper rebuttal. The concern is that there are two areas that Mr. Gully would be asked about, both of which are part of petitioner's burden that they have had to carry all along, and neither of which arose for the first time in the mayor's case. First one being any evidence related to the Article 3 confidentiality violation, and any evidence regarding what the mayor knew or did not know about the FEMA narrative or any sort of slide alteration before February 20th. That issue is central to petitioner's Article 1 charge. Petitioners knew both issues. They bore the burden on both issues, put on their evidence, and rested. The mayor's denial of allegations does not convert evidence they failed to offer does not convert evidence that petitioners failed to offer in their case in chief into rebuttal. They cannot wait until the mayor rests and then fill holes in their affirmative case. The order of proof matters, and the rules of procedure in this court, in this case that were adopted by this tribunal, specifically reference rebuttal. And so rebuttal means rebuttal. First, they may intend to elicit something occurred during the November 9 CCRADC meeting that supposedly put the mayor on notice that the FEMA narrative was false, or that there was an altered slide, or both. That would not be rebuttal. That goes directly to the knowledge element of petitioner's Article 1 theory, and petitioners can't reopen their case to put on evidence regarding that issue. Second, petitioners may intend to ask this witness irrelevant opinion testimony about confidentiality and whether the mayor breached confidentiality provisions. That's not rebuttal either. That is the alleged act constituting Article 3 itself, and petitioners cannot reopen their case in that regard. Neither issue was created by the defense case. Both existed before this proceeding began, both were known to petitioners, both were part of the allegations they chose to bring, and both belonged in their case in chief. And in fact, I would state on the record, I believe that the indication that there would be a rebuttal witness was actually projected prior to the resting of the petitioner's case. So to the extent this witness provides any evidence that relates to any of those issues I just described, it is by definition not rebuttal. A rebuttal permits a party to answer new material raised by the opposing party. It doesn't permit the party with the burden of proof to wait until the defense is rested and then fill holes in its affirmative case. When this body adopted rebuttal as part of the procedures, it was adopting that particular part of Texas law. We object to the witness in its entirety as improper rebuttal and an improper reopening of petitioner's case in chief after the respondent has rested. If this objection is not sustained and before the witness testifies, we would ask petitioners to identify the particular evidence that was introduced for the first time during the mayor's case that the proposed area of testimony is offered to rebut. I ask that that objection be sustained and that this rebuttal witness not be allowed to testify.
Mr. Allison, do you have a response?
Yes. We heard hours and hours of testimony from Lee Olivari that promoted this idea and talked over and over and over again that the reason for this was the retail and public spaces, and that is the reason behind the ordinance. That calls into question, again, and it is primary to their defense, that calls into question and it actually was spoken about also with Leo Lavari and also with their other witness, who was Councilman Roy Barrera. All of that led to further testimony about what happened at CCREDC, which was specifically discussed in all of the testimony, and there was debate and dispute about that. Those disputes that were raised, this different narrative that they have raised throughout their defense, is, I believe, will be specifically rebutted by the testimony of Dr. Gully. The rules expressly allow for rebuttal testimony, and therefore we think that this witness does have evidence of value for this tribunal, and in the interest of transparency and pursuant to the express rules of this tribunal, we ask that their motion be denied or their objection be denied.
Mr. Flood.
There was no evidence offered through Leo Lavari or Everett Roy about what happened within the meeting at the CCREDC. That did not happen. There's a transcript of yesterday's hearing, and that evidence will not be found. And so this is improper rebuttal. This is evidence that clearly could have been presented during petitioner's case in chief, and we would again re-urge our objection that it is simply not true that the evidence yesterday included evidence about from witnesses about what happened. Mr. Roy was not at the meeting. Ms. Olivari was not at the meeting, and that was not evidence offered. None of that was offered by the mayor. So this is improper rebuttal.
Do we have yesterday's transcript?
Do I have them?
I received a rough draft from the court reporter last night, and I'm happy to forward it for review.
I don't have it. I will tell you that I know we went specifically over the CCREDC meeting that we have the meetings from executive session on, and we went specifically over those. And so it has absolutely been a part of their case that we are now rebutting.
In the record, there will not be found any offer by the mayor regarding that. That's simply not true. To the extent council wanted to try and inject part of its case into the mayor's case, that's fine. That's different. That's not the same thing as something new and different offered by the mayor in her defense. So that is a mischaracterization of the testimony yesterday, I believe, and that there has not been the grounds laid for this rebuttal witness. Simply, I did not lay that.
Well, to the extent he brings up an issue, which he did, which is this second narrative they want everybody to believe now, to the extent they bring up that issue and we try to refute it by going into the actual meeting minutes of the CCREDC meeting, that was not even objected to by them at the time because it tends to rebut what that witness was testifying to. They know that. And that opens the door and absolutely allows me to bring a witness to fortify that additional information, which is the same rebuttal to what Leah Oliveira said.
No.
So we would ask that the motion to overrule their objection be made and that the objection be overruled.
What I just heard is that it was an attempt to inject by the petitioner. And so, again, that is not the way rebuttal works. It is to respond to new evidence provided by the defendant or respondent, and that did not occur. There was no testimony at all about internal EDC meetings offered by the mayor.
It was new evidence. Yeah, it is new.
What's the specific evidence brought up that needs to be rebutted? Because I thought the two witnesses, one was what happened at council, and the other one was what happened at the type B board. That's her particular scope of knowledge.
Right. But she had a narrative, so to speak, that talked about why she voted for it, and then she tried to say that's why other people voted for it. And I'll remind you that we've never deposed her. First time we've ever heard from that witness. There was a tremendous amount of new information about that tended to discredit or undermine what happened at the CCR EDC. Because of that, I went into the notes we have, or the meeting minutes that we have from CCR EDC with her to refute what she said. But I'm entitled then, when that is the first time I've ever heard that evidence, I'm entitled then to have a witness then come and support what I think is in those notes from CCR EDC as additional evidence to rebut what she said for the first time, never heard it before.
But what did she say specifically? What did she say specifically? Because her knowledge was limited to my understanding of how they voted.
Well, it actually goes back to the same staff people, if you'll recall. The CCR EDC staff prepares what goes in front of CCR EDC, and the CCR EDC staff prepares what goes in front of Type B, and the CCR EDC staff prepares what goes in front of the city here. So there is a common thread there throughout that I think needs to be rebutted and clarified.
All that evidence was included in the petitioner's case in chief, what I just heard. All of that, every single one of those facts he just stated was contained in petitioner's case in chief.
Anything from that witness that contradicts?
I can't hear you if I...
Push it.
I didn't hear anything what she testified to that contradicted the position of the prior testimony of what might have happened at EDC. That only that when it came to them, there was a presentation asking for money for infrastructure and then the street issue. And they only voted on the street issue and disregarded the element or consideration of infrastructure. So she had no personal knowledge and didn't really tie back into the previous EDC meetings. That's my recollection of her testimony.
Yeah. I think her testimony brings into question all of that with the same staff members that worked on exactly that piece of it. She repeatedly took the position that she was very clear and everybody else was very confused. And that is the first time we've ever heard that, and I think we're entitled to rebut it.
Not evidence offered by the mayor in her case in chief. That's just simply inaccurate. The fact of the matter remains that the attempt to elicit testimony about what happened during the November 9 EDC meeting is not in rebuttal to anything that the mayor placed into evidence during her case in chief. It only relates to an issue that was raised and was attempted to be addressed in petitioner's case in chief. Rebuttal is not available to fill a hole that is contained within petitioner's case. And that's what they're attempting to do, and we object for that reason.
Did Roy Everett ever express any personal knowledge about what happened at EDC?
Well, he definitely testified about what happened at CCR EDC. He was not personally there.
The answer to that question was no.
I don't see rebuttal. That's y'all's decision. I don't see it.
Is there a sentiment from this board whether to sustain or to allow the rebuttal? It's been presented, both arguments. and we've heard from our counsel. And for clarification, this is to allow the rebuttal? So there's a motion and a second to allow the rebuttal to continue. All in favor say aye. Aye. All opposed say nay.
Nay.
Yes, sir.
I'm going to do a quick sound check and then see if I can also, I guess, do video. Hold on one second. Dr. Gully, we are in session. Can you hear me? We are in session.
Yeah, I hear you well.
Can we hear? Okay. Dr. Gully, can you hear me okay?
I can hear you perfectly.
Okay.
Mr. Allison, if we
I'm
can
sorry,
allow
yes.
Ms. Rebecca to swear in the witness.
And I'm just going to simply object to the witness's remote swearing in. It's improper under the ordinance, under the city ordinances and the city charter, and it's also, there's no precedent for it under the city charter, and it's also improper under Texas law.
Okay, I don't know of anything under the city charter.
We allow for remote participation in our regular meetings.
Yeah, but there's no vote, so I can double check with our city attorney if you like.
Do we have our city attorney present?
We have an assistant city attorney present.
Okay. Our city manager's bringing her out.
Dr. Gully, if you'll hold on one moment, please. But we are still in open session.
Hi, Miss Lisa.
Yes, I was checking. I didn't find anything that would prohibit it. So I think it's
Okay.
allowed. Thank you.
Objection, there's nothing that permits it. And so this is there are definitely, under the articles, under the rules of procedure, allowed for the calling of witnesses, subpoenaing witnesses, and Mr. Gully, Dr. Gully, is not here in the chambers, and so there's nothing in the rules of procedure that afford a remote swearing in of a witness, and there is nothing in the city charter that allows the swearing in of a remote witness, and there is nothing under Texas law that allows the witness in this situation to be sworn in remotely, and so respondent objects for that reason.
And I would respond to that by saying that the rules adopted here expressly allow for witnesses to be called who can be sworn by somebody who is qualified to administer an oath. We can do that here. And he says there's nothing allowing it in Texas law. We do it all the time at the courthouse.
Miss City Attorney, do you have advice here?
No further comments. So
Based on interpretation of the adopted rules, can you advise?
I think it's fine to proceed.
Fine to proceed to
Yes,
allow a
ma'am.
remote?
Yes.
Should we allow the remote, in addition to certifying location? I believe it was said that Ms. Rebecca Huerta, who is administering oaths through these proceedings, can do that remotely. Is there any other information she should obtain?
I don't believe so, no.
Ms. Rebecca?
Yes, I'm a notary public, so.
And I renew my objection. There's simply no empowering ordinance. There's no empowering code provision. There's no empowering provision of the city charter that allows for this particular form of testimony. And so I would object to it on that basis. And also, it does not meet the requirements under Texas law for a remote swearing. And I'm asking for a ruling, please, yes.
Do we have a ruling from the board? I'm sorry?
Second.
Motion and second to overrule. All in favor say aye. Aye. Any opposed say nay. Motion carries. Thank you. Ms. Rebecca?
I do have one more objection, I'm sorry. My apologies. Quickly. I object because it violates my client's fundamental right of confrontation to not have Dr. Gully in chambers for an examination. And so for that reason, I also, and that's more of a constitutional violation, and that is separate and apart from the code and statutory provisions I object to earlier. This would be a inability to confront the witness, and so that's a separate objection. It has to be ruled upon.
Do you have a response, Mr. Flores?
Sure. Again, happens all the time. You can confront people over a video conference. You can examine them. You can cross-examine them. We do it all the time in civil cases. They do it all the time in criminal cases. It is something that occurs frequently and is a courtesy extended to witnesses. And I think we meet all of those parameters, and as such, there's no fundamental deprivation of any constitutional right by having them confront this witness over video, audio, rather than in person.
And without the ability to tender exhibits to them or anything like that. So
we have the ability to tender exhibits by Zoom.
I'd stand on my objection, please.
Okay.
Ask that it be ruled upon.
We have a motion to overrule. And a second. All in favor say aye. Aye. Any opposed say nay.
Nay.
May I proceed?
I think so.
I think she needs to swear him in.
Yes, of course, as soon as Ms. Rebecca swears in the witness, yes.
All right, Mr. Brian Gully, Dr. Brian Gully, raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Dr. Gully, can you hear us okay?
Yes, I can.
And we can hear you fine. This is Doug Allison, and I'm going to start by just asking you to state your name, please.
Dr. Robert Brian Gully,
And where do you reside?
14202 Playa del Rey, Corpus Christi, 78418.
And how long have you been a resident of this community?
73 years.
Okay, and go ahead and tell us what your background is professionally.
My training and occupation is oral and maxillofacial surgeon and a businessman.
And specifically, have you been active in some of the local community boards and maybe even city or I know port boards?
2 terms of port commissioner and then serving on the EDC, the Type A board, ISAC board, Chamber of Commerce, multiple boards.
Yeah.
But the aquarium executive board, and I'm on the advisory board of the University of Texas Marine Science Institute currently.
I'm going to get sort of right to the point. Did you serve on what we call the CCR EDC board in 2023?
Yes, I did.
And were you serving on that board when the Homewood Suites project, if I call it that, do you know what I'm referring to?
Yes.
When the Homewood Suites project made their application for $2 million through the EDC, RRE, Corpus Christi Regional Economic Development Corporation, when the Homewood Suites made that application, were you on that CCR EDC board?
Yes, I think I was the vice chair that time.
And was Mayor Paulette Guajardo also serving on that board at that time?
Yes.
And I will tell you that this tribunal, the city council members that are before us right now, that this tribunal has already received into evidence the meeting minutes from the confidential meeting that occurred when a vote happened on that project. Do you understand what I'm referring to?
Yes.
Okay, in other words, that's already, and I know that usually there is some sort of a confidentiality privilege, but those documents have already been produced to us about what happened inside that confidential meeting and admitted into evidence. So there's no longer, I think, a confidentiality issue. Do you understand what I'm saying?
Objection.
Yes, I do.
Okay. And let me just ask you.
Mr. Flood.
Give them
Pardon?
a little bit of time to make an objection before you answer.
Yes, sir. Mr. Flood.
Yeah, my objection was that the premise that he presented the witness with was a mischaracterization of the prior testimony. And so that specifically that the confidentiality related to the information received as opposed to the actual meeting itself. And so, and the only premise for that was a question of Mr. Culbertson that counsel asked Mr. Culbertson, are those meetings public? And Mr. Culbertson said, no, we are a private 501c6. So that is not testimony. That establishes that the meeting was confidential. And so I'm objecting to it on that basis.
Yeah, I've asked it, he's answered it. I'll go to the next question.
I ask that the objection be sustained because it was a false premise presented to the witness. And so I ask that the question itself, that the objection be sustained and a different question be asked.
I think the correct response to that probably is that the tribunal will recall the evidence.
Okay, we'll sustain the objection. Thank you.
Dr. Gully, were you at that meeting when there was discussion about whether or not to approve an incentive award for the Homewood Suites project? And by that meeting, I mean at CCREDC.
Yes, I was.
Was Mayor Paulette Guajardo at that meeting?
Yes.
Who else, if you recall, would have been at that meeting?
There's about more than a dozen people at that meeting. Bart Brazelton, Sarah Tyndall, who was presiding as a head staff member because Mike Culbertson wasn't at that meeting. There would have been I don't remember exactly which meeting people were there, but there was quite a few of the regular members. I think Dennis Black was I don't remember everybody that was there. I didn't pay that much attention to it, but there was a pretty full meeting and we had a quorum.
Okay, and would you rely on the meeting minutes to identify who was actually there?
I would have to, yes.
Okay. And so do you recall there being a debate about whether or not to give any incentive award to the Homewood Suites?
We had a strong discussion.
And was the mayor advocating for any position?
She was advocating for the $2 million for the project. And I think she'd seconded the motion. There was a motion made and she seconded it.
Okay. And did you support that or oppose it?
I opposed it.
And why did you oppose it?
For numerous reasons. Although the two people, Philip and his partner, Devin, I consider friends of mine, I didn't like the project for multiple reasons. I don't think it was a good look that Philip had just come off our board a few months ago. I thought that if you look at economic development programs, it starts at the best projects all the way down to the worst projects for economic development. And these hotels are considered down towards the bottom as the least desirable projects. That was the main reason. I felt like it was way too much money for one private project like that, because I'm not in favor of projects that aren't somewhat unique. In other words, using taxpayer money to incentivize one project that competes with other projects, like the other hotels in the area. They'd already received quite a bit of taxpayer money in the TERS
the TERS fund. And I gave several reasons, but really it's just, I like because the low wages that hotels generate, and the fact that they don't bring any new business to town, they just accommodate business that's already coming to town. So I had several reasons. I thought it was way too much money, and I thought there were much better projects to use the money on. And then I disagreed with the reasons they gave why they needed that much money.
And what was,
I'm gonna level an objection. The testimony is not in rebuttal to anything that was in the mayor's case. This examination proves the point as to why this witness should not be allowed to continue testifying in rebuttal. There is no attempt to rebut anything because they can't. Everything they're offering relates to the burden that they assumed in their own case in chief. And so I would object to any further testimony from this rebuttal witness. There's simply none.
predicate at this point.
So you're renewing your objection?
I'm renewing my objection based upon the evidence, based upon the testimony that's been elicited. It, once again, is not in rebuttal. Not one thing has been in rebuttal to anything in the mayor's case. It's not rebuttal evidence, and I object to it going forward.
Yeah, my response is very simple, and that is, at this point, I'm just laying predicate. I'm trying to get to the point that we're trying to make here that I've articulated already and that you've ruled on already. And so.
Then I'll go ahead and call the motion. I have a motion and a second to overrule the objection. All in favor say aye. Aye. Any opposed say nay.
Nay. Dr. Gully, the things you just articulated, did you voice those concerns during the meeting?
Yes, I did.
One of the things you just said, and now said you voiced that concern during the meeting, was the reason that they were asking. Did you understand during the meeting that the reason applicant was asking for the $2 million was for what was characterized as newly defined and recent changes to FEMA rules?
Yes.
Was that very clear to the meeting that that was the reason for the ask for the $2 million?
Objection. The question is vague. He simply said, was it clear to the meeting? And so that is clearly asking for hearsay. He's asking for other people's state of mind. There's no predicate.
Can you
laid
restate your question, Mr.
Sure. Was there debate about that issue, about whether or not the FEMA rules were being or had been newly defined and were recent changes?
Objection, hearsay.
About that?
Objection, hearsay.
Yes.
I'm going to ask the witness be instructed to not answer questions until after objections are ruled upon. The witness was asked specifically a hearsay question, and I'm objecting under this procedure's rules against hearsay. And so objection, hearsay.
Understood.
He heard you. Okay.
I asked my objection to be sustained, my hearsay objection be sustained, and that the answer by the witness that was rushed.
Right now, the only question is what's their
stricken,
discussion, which is not hearsay.
I have a motion to sustain. We have a second. All in favor say aye. Aye. Any opposed, nay. Sustained. Thank you.
Dr. Gully, what was your personal experience with regard to how long, or any of your knowledge during that meeting about when or whether or not there were new FEMA rules?
When the comments were made that this project was going to cost more money because of the recent changes in the FEMA rules and the base, it's related to the base flood elevation, I made a comment that I knew personally for a fact that Mr. Ramirez was aware of that quite some time ago, because I had personally made him aware of that, because I had sold him some of that property.
Did you sell Mr. Ramirez some of the property that the project is located on?
Yes.
And back at that time, which is, I guess, 2021-ish, does that sound right?
Yeah, somewhere back then.
Back at that time, did you make it very clear to Mr. Ramirez that the FEMA rules, new FEMA rules, were in effect back in 2021?
Yes, I did, because at that discussion, he was talking about tearing the buildings down, and I specifically was asking for a little more money because one of the buildings had been renovated. And he said, we're just going to tear them. And I said, well, if you tear them down, you're going to have to raise the base flood elevation. And he said, yes, he acknowledged he was aware of that.
Now, did you share that discussion that you had with Philip Ramirez back at the time of his purchase? Did you share that discussion with the people at the CCR EDC meeting when this was being debated, including the mayor?
Yeah, everyone at the meeting, I made it clear that he knew that was going to be an issue, a problem, back when I sold the property, because at the time I sold the property, he said he was going to build a building for the university. And that's, at that time, I told him, you need to you are aware that you're going to have to, raise the base flood elevation. Like I said, he's a friend of mine, and I did not want to sell him a piece of property that he didn't understand, had an issue with.
Okay. And when you were in the CCR EDC meeting, within earshot of the mayor, did you make it clear to the mayor, at least from your intention in making speech or providing information, did you make it clear that Philip had long known about the FEMA rules?
Yes, I did.
And do you believe the mayor was clearly within earshot of you explaining all of that to the group?
I think I made everyone clear about that when I said it. I thought it was important.
And so in that sense, do you think you made it clear that the changes in FEMA rules were not new, so to speak?
Objection. There's been no predicate laid for the question about changes. Zero.
I'll rephrase.
Thank you.
Yeah, we're talking about, do you understand that we're talking about FEMA rules that the changes had been initiated back in about 2020? Does that sound right to you?
Yes.
And did you make it clear to the group that there were no new changes, that the changes had been around for years during the CCR EDC meeting?
Yes.
Okay. Did the mayor then back down from wanting $2 million for the project?
Objection. There's been no predicate laid for the timing of his statement. That was argument by counsel, and so I object to facts not in evidence, and I object to the argument.
I'll rephrase. During the meeting, who made the motion to award $2 million?
Bart Brazelton.
By the way, are you familiar that the recommendation, the highest recommendation for a dollar amount from CCR EDC staff was about $1,043,000?
Objection. The objection. The word recommendation is a mischaracterization. That was the model. That was a product of the RIMS 2 modeling.
I'll rephrase.
Thank you.
Are you aware that the model recommended at most $1,043,000?
Yes.
And who seconded the motion for $2 million?
Mayor Guajardo.
Did your providing the information about, hey, these are not new rules, they've been around for a while, or however you articulated it, did that dissuade the mayor at all from the vote?
Objection. There's not evidence. Objection. There's not evidence that he stated those words in the meeting. So that's a mischaracterization of prior testimony.
Yeah. If I mischaracterize your testimony, please let me know, Mr. Gully, okay, or Dr. Gully. Okay. Did any of the things that you told them during the executive session that you told to the mayor dissuade her from pushing for $2 million?
No.
Was there even
apparently not?
Was there a discussion about, hey, maybe you should pull down your motion?
Yeah, and I'm not sure if I'd said it or one of the other meetings, but and the mutual decision was to let it go to a vote.
Okay. And did that vote for $2 million fail or succeed?
It failed.
Okay. Do you have any doubt in your mind, and you can only speak for what you perceived during the meeting, do you have any doubt in your mind that you made it very clear to the mayor that the idea that this was new rules by FEMA was untrue, or did you make that clear?
I feel like I made it clear to everyone.
Okay, thank you. No further questions.
And Mr. Gully, you feel like you made it known, but you can't state for certain that you did. True? That's what you just testified to.
Well, from the vote, you know, and from some comments that other members made, you get a feel for the room, and of course the vote tells you exactly what they feel.
And that it would be your testimony that if Mr. Ramirez, that if his presentation to the EDC board was contained a narrative that he was surprised by in 2022 to alleged changes, what you're saying is that that would be, it was discussed according to your testimony, that particular issue was discussed. Is that what you're saying?
I'm just going to object to the question. It's confusing.
It is confusing.
Mr. Flood.
Dr. Gully, did you, at that meeting, is it your testimony that the narrative that in 2022 there had been, that Mr. Ramirez was surprised in 2022, was that exact narrative discussed?
It's kind of confusing, but at the time I told
And I'm
Philip
sorry.
Ramirez about the FEMA rules, then at that time he did not seem surprised.
Is it your I'm sorry, is it your testimony that Mr. Ramirez was at the November 9 meeting?
Excuse me, again?
Is
Repeat
it
that?
your testimony that Mr. Ramirez was at the November 9 meeting that you were just talking about?
No, he was not at that meeting.
Okay.
He was not at the EDC meetings.
Okay.
Right.
I just want to make sure the record was clear. And so my question to you is are you telling this tribunal that the issue of surprise, okay, do you understand when I say that?
The issue of surprise about what?
About changes in a FEMA floodplain maps. Does that narrative ring a bell in your mind at all?
I'm not sure I completely understand what you said. You mean in that meeting, was anyone surprised about that?
No, I'm asking, in that meeting where you say this issue of where FEMA maps was discussed in an EDC meeting on November 9th, right? November 9, 2023, correct?
That was the meeting we voted on it,
Okay.
right?
Yeah,
November 9th?
exactly.
Okay.
In that meeting, it is would it be your testimony that there is some sort of discussion about whether or not it would be credible that Mr. Ramirez was surprised in 2022 about alleged changes in the FEMA map? Was that particular issue discussed? It's a yes or no question.
No, I don't believe that.
Okay.
In that detail, whether he's surprised back when I originally talked to him about it. No, I don't think we discussed that particular part of it.
Okay. And also at the November 9 EDC meeting, there was absolutely no discussion regarding any sort of altered slide or anything like that, right?
No, not to my knowledge, no.
No. And so what we know is that on November 9th, 2023, at a EDC meeting that convened at 8 a.m., there was a discussion, a spirited discussion about whether or not the EDC board would recommend $1,043,000, which was the RINS model, or $2 million, which was the request, or some other number. Is that fair to say?
Yes.
Okay.
But it went in an order. First, the motion was made and voted on.
Okay. I object non-responsive everything after yes. And so we know that was the spirited discussion, correct?
it was a spirited discussion, I would say, yes.
Yeah, and Mr. Brazelton, fair to say, was kind of espousing the approval of the 2 million and was advocating that we need to support projects like that. Is that fair to say?
Probably fair to say, yes.
Yeah. And it is also true that you do not have any specific recollection of the mayor, in her words, advocating one way or another. She simply seconded and voted in favor of the one that failed 3-6. True?
No, they both seem to be supporting the project.
And who was the third person? Who was the third person that voted? The minutes don't reflect it. Based on your recollection, who was the other member that voted?
You know, I don't remember, but it was on my side of the row, and therefore I might not even be able to see them because other people between me and them, but it was someone on my side of the row.
Okay. And so most definitely, when y'all voted to support that 1,043,000, you absolutely, under no circumstances, were supporting any sort of false narrative regarding FEMA flood maps. Fair to say?
I was not aware of anyone mentioning any date or maps or anything like that at that meeting.
Okay, all right. Was Mr. Almaguer at that meeting?
I believe so.
Okay.
I believe he was down. He would have been at the far end of the row that I was on, probably.
Okay. Has the petitioner's counsel in this case, who just asked you questions, has he ever represented you?
Excuse me?
Has Mr. Allison ever been your lawyer?
Yes, he has.
Is he current your lawyer?
No, that was a case some time ago.
Okay. Are y'all in any? Are y'all business partners?
In no way, no.
Okay. This past May, Mr. Allison was married in Italy, correct?
Yes, he was.
And you went to that wedding, didn't you?
Yes, I did.
And where was it?
In Italy, someplace on the Highland Mountain in Italy.
It was.
I've never been to Italy before.
It was an extraordinarily beautiful place, right?
It was a beautiful place.
All right. And at that wedding that you attended, it was a small group from Corpus Christi that went?
Yeah, pretty good sized group, yes.
Yeah. And at that wedding that you attended, and that was just a few months ago, back in May, correct?
Yes.
All right. And at that wedding that you attended...
At this point, I'll interpose an objection. At some point, I think it gets too off track. I think he's made a point in terms of we definitely know each other and have a relationship.
A couple more follow-ups on that. At that wedding, the officiant at that wedding, who was the officiant at the wedding, who married Mr. Allison and his new bride, was Tammy Watts, correct?
Yes.
All right. And Tammy Watts is the wife of local lawyer Michael Watts, correct?
Yes.
And Mr. and Mrs. Watts were there, right?
Michael and Tammy, you mean?
I'm sorry.
Michael and Tammy Watts, yes.
Yes.
Yeah.
And at this point, I think
Mr. Gully, I've got one more question for you in that regard.
Far enough.
Mr. Watts's mother is Judge Sandra Watts, correct?
Yes.
All right. Now, can I have a minute to confer? Just 1 second.
Quick second.
pass.
You pass?
Yes. I was going to show pictures of the wedding because it's fantastic, by the way.
Thank you
It's
very much.
beautiful.
Thank you. By the way,
Beautiful wedding.
and you are out of the country right now, I think, correct?
Yes.
And why are you out of the country instead of being here in person?
Well, my son is, it's his birthday also, but he's proposing to his girlfriend of 8 years that they've been together since 10th grade.
And I hope she found out before we just found out.
Yes, yes.
Okay.
It was very nice, very
Now,
nice.
All of those relationships being considered, I mean, I think the implication is that somehow you would maybe be untruthful because you and I are friends and I have represented you in that case years ago. Have you said anything in your testimony that is untruthful?
No.
Thank you, sir.
And Dr. Geller, where are you right now?
By the way, I passed.
Well,
In St. Lucia?
I apologize. So you're not in the United States?
No, I'm in St. Lucia.
Okay. And when did you go?
Friday?
All right.
Saturday.
So
I'm coming back tomorrow.
okay. And today is Friday the 7th. This trial started back on July 22nd, which is 2 weeks ago. Were you in Corpus Christi on July 22 and 23?
I might have been, I was in South Texas.
Okay.
I was not in Corpus, no.
You were, it sounds like you were maybe on a ranch or something?
Yeah.
Where's that?
In it's west of Fremont.
Oh, okay. So not
We
too
had
far.
water issues.
Okay. Less than 150 miles from Corpus Christi?
Yes.
All right. And so that's where you were on July 22nd and 23rd?
Yes.
Okay. I pass.
Nothing further. May this witness be excused?
Go to the
Yes.
beach?
Dr. Gully, I'm going to sign off. Thank you very much, sir.
Okay, thank you.
Mr. Allison, you have any other witnesses?
Close.
I would request a break to assess whether or not I need to call a rebuttal to a rebuttal.
Okay, we'll take a 5-minute recess.
Thank you.
Okay, I think we're all back. All right, then we will reconvene this meeting, and Mr. Flood.
Respondent closes.
Thank you. Mr. Allison. I'm sorry, on your microphone?
Nothing further from petitioners?
Thank you. Do you rest?
Yes, we rest and close.
And Mr. Flood?
Yeah, again, rest and closed.
Okay, then at this time, I would like to recess until 3 p.m., and we'll resume at that time.
Thank you.
Thank you.
Thank you.